So let's talk a little bit now about the FISA statute. So some of the background of the FISA statute I think is really fascinating, and it's interesting to see how it's developed. So as we just mentioned, and as kind of reflected in Executive Order 12333, there is this history of the U.S. intelligence services under the direction of the president, or sometimes without really the president's direct knowledge, kind of running amok, and particularly during the Cold War and particularly during the Vietnam War, going off and doing things that were of dubious legality, including assassinations. This led to some congressional investigations and a report called the Church Committee Report. You can look that up if you're interested in it, that details some of these things. This led to kind of a debate in Congress about, well, what is the role of the intelligence services? Where do they fall? Are they simply under the control of the executive, or should there be some more specific congressional oversight, and what should the role of the judiciary be? And that gives rise to the FISA statute. And so originally what the FISA statute is designed to do is to say, when the executive is authorizing foreign intelligence surveillance, that there needs to be some kind of procedure where the executive branch goes, at least in some cases, gets a court order, other cases doesn't have to get a court order, and there's at least a record of that. And so it was relatively uncontroversial prior to 9/11 and the amendments in the Patriot Act and the much more extensive use that was made of it after 9/11. It was certainly used, and it was regularly used for foreign intelligence surveillance, of course, through the end of the Cold War, but it's really the war on terror that changes the dynamic. Why does the war on terror change the dynamic? Well, I give you an excerpt from the 9/11 Commission report, and as you look at that, you can see some of the findings in that report. It's, of course, I think, useful and chilling for us to go back and look at that and remember where we were on 9/11 and just after 9/11. But one of the main criticisms and findings of the 9/11 Commission report was that various pieces of the federal government knew about some of the aspects of Al-Qaeda's plot to attack the World Trade Center. Even if not in detail, at least knew enough about it that if someone had been able to put these pieces together, the government may have known and may have been able to foil the plot. And in particular, the FBI had some pieces of information that it couldn't or wouldn't make available to other branches of the government, because the main role of the FBI was investigating criminal activities, while you had the CIA doing foreign surveillance and investigations and covert activities, and you had the NSA collecting signals activity. And because of some of the concerns about the legal requirements, there were policies put in place to keep some information from flowing. So one of the main concerns of the 9/11 Commission, which was a very highly regarded bipartisan commission, was that these walls, these intelligence walls, needed to be broken down. One of the ways that happened was through the Patriot Act, and one of the things that the Patriot Act did was to expand the ability of the federal government to acquire and use information that even involved U.S. citizens, or that encompassed U.S. citizens. Why the concern about U.S. citizens? I mean, why not just say, look, this is Al-Qaeda, these are all foreign nationals, we really don't have these concerns. Part of the problem was that the Al-Qaeda cells were sleeper cells in the United States, and they did involve communications with and activities with people who were U.S. citizens. So it wasn't really the case anymore that you have a foreign nation state and foreign agents who are relatively easy to identify. You have now foreign nationals who are acting not necessarily on behalf of a nation state, but on behalf of a loose agglomeration like Al-Qaeda, who are working with people who also are U.S. nationals, some within and some outside the United States. So how do you do that kind of activity without tipping them off, getting the right information, but also regarding the constitutional rights of those who are U.S. citizens. That makes it really difficult, and that's part of what the changes to the FISA statute were designed to do. We should also note here, and we'll talk a little bit more about this in the materials for next week, but in addition to procedures under the FISA statute, the George W. Bush administration began a wiretap program outside even of the FISA statute. So as we'll see, the FISA statute as amended by the Patriot Act doesn't really require a warrant. It does require a court order, but it's a relatively low showing. It doesn't require a warrant on the same kind of probable cause that we expect for a crime. But even outside of that, the Bush administration was going ahead and doing collecting internet information, emails, and so on without any kind of court order, and asserted as authority for that the inherent presidential authority in time of emergency or war. That was even more controversial. I would say even more controversial. It was also very controversial, and we'll talk about that a bit more next week. What we're going to focus on this week is the surveillance under the FISA statute. So the FISA statute has been on the books. Obviously, the Patriot Act amended it. All of that, of course, is public record, is public knowledge. What wasn't public record and wasn't public knowledge was either the warrantless program and the non-court order program the Bush administration had enacted, or the scope of the metadata collection that was in fact authorized by the FISA court. We only learned about those activities through the documents disclosed by Edward Snowden. So in class we can talk a little bit about what we think about Edward Snowden. Obviously his disclosure of those documents violated a ream of federal laws, and there are people who consider him a traitor, and there are others who consider him a patriot, and we can kind of debate that in class. We knew that there was some of this kind of activity going on, but nobody knew the extent of it until these disclosures came to light. And of course we knew what the statute said. So what does the FISA statute say? It does establish a special court, the FISA court. The FISA court is made up of sitting federal district judges selected from various districts with a certain amount of expertise. So it's sort of a specially designated court of sitting federal judges that periodically meets. There is also a FISA Court of Review that is appointed from federal district and circuit judges that has the ability to review the decisions of the FISA Court. Now the trick with the FISA Court is that most of its proceedings are classified. So it is therefore a court that operates in secrecy. And that, as a lawyer, that ought to raise some alarm bells and some red flags. Now, it is not necessarily the case that courts never operate in secrecy. There are circumstances when courts do operate in secrecy. Even in civil cases, I've been in civil cases where there have been protective orders. In fact, it's pretty routine in intellectual property litigation, which I did a lot of, to get a protective order that seals at least part of the record. I can only recall one occasion in my sort of practice life when literally the federal marshals sealed the courtroom doors because of a protective order and some testimony that was happening. But it does happen sometimes. But there has to be a specific showing for that to happen. For an entire court, for most of its proceedings to be classified is pretty extraordinary. Now, I do have a friend who used to head the cyber division for the FBI here in Newark. He's now a private consultant. And he's the only person I know personally who ever testified before the FISA court. And he did that when he was an FBI agent. And, what he tells me is that the procedures were very rigorous, that the court asked a lot of questions, that the government really had to go in with a very strong case before it was able to justify all this. And that very well may be true. Nevertheless, it does raise a concern about the fact that it's not truly an adversarial process and that it is done in secret. So what can the government get under the FISA statute? There is foreign intelligence information that the government can get without any kind of court order at all. So there can be electronic surveillance for up to a year if it is solely directed at communications between or among foreign powers, or acquisition of certain kinds of technical intelligence. And there's no substantial likelihood that the surveillance will acquire any contents of communication involving a U.S. person. So that's there, and that's part of kind of the difference between sort of foreign affairs and domestic surveillance. But of course, as we mentioned, a lot of the kind of activity that the government was concerned about after 9/11 was communications that were, in one way or another, involving U.S. persons who may be connected with terrorist cells involving foreign persons. So in that case, it would be necessary to obtain a court order. So what would the court order involve? So if the surveillance is likely to involve communications of a U.S. person, a federal officer must make a certification to the FISA court, and the certification must be approved by the Attorney General. Why does it have to be approved by the Attorney General? It escalates this issue and requires the very highest level of approval. This is supposed to limit the circumstances under which some federal agent might decide that they want to do this. The certification has to certify that the ultimate target of the surveillance is a foreign power or an agent of a foreign power. Minimization procedures have to be adopted. We'll talk in a moment about what that means. And the certification has to certify that a significant purpose of the surveillance is to obtain foreign intelligence information. Now, this is an important change that the Patriot Act made. Previously, the certification had to state that the primary purpose of the surveillance was to obtain foreign intelligence information. The statute was changed to say that it's a significant purpose. So, what's the difference? Primary purpose, significant purpose. We can see the difference in that language, and as lawyers we know that can make all the difference in the world. So significant purpose is really broad, and you can scoop in a lot of things under significant purpose that perhaps you couldn't get under a primary purpose test. The certification also has to state that the information can't reasonably be obtained by normal investigative techniques. Now again, this does put a little bit more burden on the government, but the showing here is probably relatively minimal when you think about what normal investigative techniques might involve in these kind of circumstances. So the certification is filed with the court, with the FISA court, and then the FISA court then has to determine whether there's probable cause to issue an order approving the requested surveillance. So what is the probable cause? Now, remember, the normal probable cause under the Fourth Amendment for obtaining a search warrant is probable cause that a crime has been committed, or is being committed, or is about to be committed. Right? So you've got to make a showing that there's probable cause that there's a crime, and that requires you to specify, to some degree at least, what the crime is. Here, that's not the showing of probable cause. The probable cause showing is simply that the target of the surveillance is a foreign power or an agent of foreign power, and any of the facilities that are being surveilled are being used or about to be used by a foreign power or an agent of a foreign power. This is a really low threshold of probable cause. All the court needs to do in looking at the certification, remember, it's a certification submitted by the government. It's not an adversarial proceeding. Now, of course, the government officer approved by the Attorney General has to certify this under oath, potentially, theoretically being liable for perjury if it's not true. But nevertheless, all it has to show for probable cause is that it's targeted at some foreign power or agent of a foreign power. So if ultimately the purpose is to find communications between Al-Qaeda, or today also we might say ISIS, this is not a hard showing at all to make. The court also has to find that the minimization procedures are satisfactory under the statute, and the order issued by the court has to have some specific expiration dates. It can't be totally open-ended, and you can see in this bullets here what the expiration dates included. The Attorney General can act without even obtaining a court order, even if it's going to involve U.S. persons under emergency circumstances. And when that happens, the Attorney General has to go back after within 7 days and go ahead and obtain the order. Again, we'll talk a little bit more about that in the materials for next week when we talk about emergency powers. But just note right now that under the FISA Act, and this is a common theme, the executive is allowed to take certain actions that it wouldn't otherwise be allowed to take without judicial approval in the event of an emergency. So what are minimization procedures? And this is a really important aspect of the FISA statute and a lot of the cases, and there are a number of cases that we could have read that I didn't give you to read just because it's too much volume for this module about what minimization procedures are. You will see statistics quoted, and I've put them out there myself, that something like more than 90%, well more than 90% of all applications made to the FISA court were approved, and that is true. But it's also true and fair to point out that there are numbers of instances in which the FISA court approved applications only with some amendments to the minimization procedures. So the statute defines what minimization procedures are, and as you can see from the definition in the statute, they're all designed at trying to limit the circumstances under which any identifying information of a U.S. person will get out to the government. And effectively, and we'll talk a little more about this in class, the bulk metadata procedures that the government did get approved by the FISA court required the information to be kept by the government and not to be looked at until the federal government showed that there was some specific terrorist-related reason to look at it, and then they were able to pull out of those records a certain number of what the minimization procedures in those orders called hops. In other words, you had the terrorist suspect and then a communication hop to another person, and then a communication hop to another person, and they were allowed to slurp a certain amount of that and then look at it. We'll talk a little bit more about that in class when we talk about what this resulted in. Just see now statute and what the statute required.